The practical implementation of the provisions on the competence to settle parents and child identification, Part 2. 2. Is parents and child identification without dispute under the court's jurisdiction for petition or under the competence of civil status agency. As stated in the competence to identify parents and children in Part 1, the petition for determination of fathers or mothers for children or determination of children for fathers or mothers is a civil matter under the jurisdiction of the court. According to the Civil Procedure Code 2015, it is clearly understood that these are non-disputed requests because the civil matter is a situation where agencies, organizations, or individuals have no dispute but request courts to recognize or not to recognize a legal event. According to Law on Marriage and Family 2014, the situation of parents and child identification without dispute is under the competence of civil status agency. It is stipulated in the Civil Procedure Code 2015 that the petition for determination of fathers or mothers for children or determination of children for fathers or mothers according to legislation on marriage and family is under the jurisdiction of court. Thus, there are two competent authorities to settle the parents and child identification as follows. Firstly, the Civil Status Agency by recording in the Civil Status Book. Secondly, competent People's Court by settling a civil case and sending the decision to resolve the civil matter to the Civil Status Agency for issuing an instruction to the persons requesting. The final result of parents and child identification without dispute is the record in the Civil Status Book for issuing an instruction to the persons requesting. Should the competent People's Court or the Civil Status Agency be chosen. Empowering two agencies to deal with the identification of parents and children leads to the reduction of workload in People's Courts. However, there are many differences in the procedures and order for determining parents and child between the People's Court and the Civil Status Agency. Specifically, regarding the petition, firstly, when filing at the People's Court, the petitioner must submit the application with the prescribed contents and clearly state the request for settlement, the reason, purposes, and grounds for requesting the court to resolve the civil matter. Enclosed to the petition, the petitioner must send documents and evidence to prove his or her claim is correct and legal. Evidences in civil cases are factual things which are handed to courts by involved parties, agencies, artists, organizations, or individuals are gathered by courts according to the order and procedures prescribed by this code, and are used by courts as basis to determine objective details of the cases, as well as to determine whether involved parties' claims or protests are well-grounded and lawful or not. Secondly, requesters for registration of parents and child recognition shall submit declarations made according to a set form and evidence proving father and child or mother and child relationship to the Civil Status Registration Agency. Proof of parents-child relationship is the written confirmation of the father-child or mother-child relationship from a competent domestic or foreign regulatory body, organization, health authority, or assessment agency. In case there is no proof of their parents-child relationship, the parents and child shall draw up a confirmation of their parents-child relationship with at least two witnesses of their parents-child relationship. Therefore, the first difference is that the court assesses the factual evidences for determining the grounds and regularity of the petitioner's request, while the Civil Status Agency based on the confirmation of the parents-child relationship when there is no proof. Is it clear that the courts are more objective than Civil Status Agency in settling the civil case of parents and child identification, because the confirmation comes from the will of the requester and doesn't reflect the factual blood relationship. There are also the disadvantages in case the civil status officers conduct the verification because the blood relationship between parents and children is best reflected by the written confirmation of medical and assessment agency. Regarding settlement order, firstly, the People's Court must carry out the first instance civil matter settlement procedures in accordance with the Civil Procedure Code 2015 as follows: receive and process petitions, notify the acceptance of petitions, open the listings to settle the civil cases. Secondly, the civil status agency shall carry out the procedures for registration of parents and child recognition in the following order: receiving dossiers, conducting the verification if necessary. If it is true and there is no dispute, civil status officers record in the civil status book and report to the president of the Mid-Level People's Committee to issue the excerpts to the requester. There are more procedures at the court than at the civil status agency. Regarding time for settlement, firstly, time for settlement of civil matter in the People's Court is at least a month and 23 days, in which it takes 23 days for the acceptance of the court and 1 month for considering the petition. Secondly, it takes 3 days for the civil status agencies to resolve the request from the date of receiving the valid dossiers. If it is necessary for the verification, it will take 5 days more. Thirdly, it takes more time for identification of parents and child at the court than registration of parents and child recognition at the civil status agencies. Regarding state fees, firstly, instant court fee is 300,000 VND paid by the petitioner. Secondly, requesting at the civil status registration agency, the requester must pay a fee based on socio-economic conditions. In the locality where the service provision arises, the collection of fees and charges. Provincial level People's Council shall prescribe the appropriate rates of fees and charges. The fee for the identification of parents and child in localities is almost lower than the fee for settlement at the People's Court. This is found that the People's Court and the Civil Status Registration Agency both have the right to resolve a request to identify a parent and child without dispute, except for the cases specified by the Marriage and Family Law, which must be settled by the People's Court. Although there are many differences in the order, procedures, settlement directions, time limits, and fees when being processed at these two agencies, the results are recorded in the Civil Status Book at Civil Status Registration Agency for issuing an extract to the persons requesting. If I had a request on the identification of parents and child without dispute, I would carry out the procedure at Civil Status Registration Agency because its procedures are simpler and faster. And the fee is lower than the cost. In the author's opinion, the identification of parents and child without dispute, excluding the cases under the court's jurisdiction, should be sought by the Civil Status Registration Agency. However, to ensure the objectivity of the identification, the confirmation of the parent-child relationship drafted by the requesters should be cancelled to avoid the mistakes and ensure the moral rights of the parties involved. 3. Renders the cost just to settle the request of identification of parents and child. Before the Circular No. 04/2020 CTBTP took effect, there had been several situations where a person not recognized as the author's parent wanting to identify the author as his or her child, or a person recognized as the author's parent wanting to identify the author as his or her child. Files a lawsuit at the court under the law on marriage and family, but the court addressed the case or issues the decision on suspension it because there is no dispute. Thus, on November 6, 2014, Department of Civil Status Nationality Authentication issues the official letter No. 5577 H2TGCTH2 getting the civil status issues Accordingly, the legal provisions on identification of parents and child must be strictly complied with for ensuring the objectivity and accuracy, avoiding taking advantage of the identification for self-interest, immigration purposes, and human trafficking. The database of request for identification of parents and child must consist of the court document to suspend the resolution of the case or refuse to resolve. The identification of parents and child due to the absence of a dispute. About the same time, there must be an evidence proof of parent-child relationship, for example, DNA test results. On July 16, 2020, Circular No. 04/2020 TTBTQ took effect. There is a provision that people's courts shall decide cases where the wife gives birth or is pregnant during the marriage period, or the wife or husband doesn't recognize the child as their common child, or another person wishes to recognize the child as their own as per law. If the people's court rejects such case, the civil registration authority shall receive and handle the application for registration of the birth of the child with another application for father-child relationship recognition, which shall include a written rejection from the court and proof of the father-child relationship. This provision aims to protect people's legitimate rights and interests. However, it now leads to the court shifting their responsibilities onto the civil status agencies, because the court rejection rate in the cases of identification of parents and child is not explicitly stated. Besides, the court rejection in the cases of identification of parents and child is contrary to the provisions of the Article 1899 of Law on Marriage and Family 2014, specifically 1. A person who is not recognized as the parent of a person may request a court to identify that whether it is or her child. 2. A person who is recognized as the parent of a person may request a court to identify that whether it is not his or her child. It can be concluded that there is an inconsistency between the law on civil status and the law on marriage and family in the identification of parents and child, which call attention to the lawmakers in terms of specification and clarity of the provisions, so that the citizens can exercise their rights and interests quickly and conveniently. Regarding recommendations, firstly, is it necessary to issue a legal document clearly stating the disputes arising from the identification of parents and child to avoid the responsibility shifting among the competent agencies and ensure the quick and convenient procedures for the requested settlement. Secondly, the unity and linkage among legal documents should be created in the regulations on the identification of parents and child, as well as relevant regulations to avoid the inconsistency. Thirdly, the cases of identification of parents and child without dispute should be solved by the civil status registration agency with quick and convenient procedures, factual and objective evidence instead of the requester's confirmation.